What's up, YouTube? It's your boy. Tonight we've got a viewer request. It's the report and recommendation by Judge Shirley in the Randall, Keith, Heather, and HATJ giraffe case. This is the secret federal treasury account case that's going on right now. It's very interesting. All right, first off, we need to take a detour and explain why this is a report and recommendation. Because one of the first things that was jumped on over at the IUV website is that it's a report and a judge's order dismissing Heather's nonsense paperwork. And by the way, thanks to the IUV website for providing these documents for free. Normally, I would have to pay $1.60 for something like this, and we're getting it for free. Plus, we got the entertainment of Heather being in jail, so thank you to them. Anyways, for the explanation as to why this is a report and recommendation, we go over to Quatloos, courtesy of Wesley Sarah. Quote, the answer to why this is a recommendation, not an order, is, quote, because Shirley is a magistrate judge, not a district judge. The district judge must rule on any case dispositive matters. Because this is a case dispositive matter, only the district judge can rule on it. Shirley cannot. Federal Rules of Civil Procedure 59, that's the citation, that's the referral to report and recommend. So now the issue goes to Chief Judge Varlin, the assigned district judge. He will review and decide, etc. Now, let's keep in mind that the intended audience for these videos is people over at IUV that are attempting to access these secret accounts. To answer one of the questions that they might have is, why should they trust Wesley Sarah? Number one, he's a licensed attorney. Number two, he gave us the citation, Federal Rules of Criminal Procedure 59, that supports his statement that the district judge has to refer to the magistrate or whatever. He cited the actual law that requires the judge to make a recommendation, not an order. So he is backing up what he's saying. He's a licensed attorney. He's an expert. Okay, now then, over to the document, the report and recommendation. I've highlighted the good parts. Quote, defendant HATJ draft states that the press-be to dismiss is not a motion. At the hearing, she alleged that it is a judgment. For reasons explained more fully, the undersigned, aka the judge, will treat the press-be as a joint pro se motion challenging the jurisdiction of the court. We got the background. We already know about that, so I'm not going to read it. Or we get to good stuff. In the press-be to dismiss, defendants Heather and Randall state that the United States, the prosecutors, judges in this district, the clerk, the FBI agent, the grand jury, foreperson, and the victim banks have no authority or jurisdiction over them. They assert that the party claiming jurisdiction has the burden of proving jurisdiction exists, and that its sworn declaration stands of law. If it is not specifically rebutted as a part of their press-be to dismiss, the defendants provide a declaration of facts consisting of 55 pages of UCC financing statements and addenda. The press-be to dismiss concludes by stating that defendants HATJ draft and also defendant Bean does not consent to any individual having jurisdiction or authority over them. At the October 18 motion hearing, defendant HATJ draft argued, among other things, that the United States is a corporation, which he has foreclosed, that the courts are the functional equivalent of banks, that judges are the bank tellers, and that the Federal Reserve and Morgan Stanley amortize all indictments. Defendants HATJ draft asserted that she filed a UCC financing statement, which resulted in a perfected judgment against the United States. Now, you got to read the notes because they contain also interesting stuff. Note 11. In this document, Heather claims that she is owed $46 quintillion payable in pre-1933 gold and silver coins. And note 13. This is a copy of the arrest warrant in which she wrote void in handwriting across each page and bearing her handwritten notes purporting to cancel the arrest warrant. She literally wrote void across the warrant, thinking that allows her to cancel it. Anyways, claimed that she has also foreclosed all domestic financial institutions, along with various international banks and financial institutions. Heather stated that she had filed a proposed order which she signed dismissing the case. Both Heather and Bean denied they are sovereign citizens. Defendant Tushi Giraffe stated that she is not a citizen of a corporation operating under the guise of government and that she is not a constitutionalist because the Constitution is a contract to which she was not a party or signatory. Instead, she maintained that the Constitution, like the United States, the entire United States codes no longer exist due to her foreclosure. Moreover, she argued that she did not consent to this court's jurisdiction because the court had not proven its authority by providing the verification of the United States Attorney Jeff Sessions bearing his biometric seal, i.e. his fingerprint. Anyways, here we get to the meat of the document, the judge's analysis of Heather's claims. Quote, the defendants have filed in excess of 725 pages. Sorry, I need to laugh at that because 725 pages is like 2 novels worth of paper. Quote, many of which are duplicates. These filings are mainly comprised of UCC findings and statements and are largely devoid of intelligible argument. However, based upon Heather's statements at the hearings on August 24 and 29, defendant Tushi Giraffe's argument on October 18, the court gathers that the defendant contends that this case should be dismissed because the court lacks jurisdiction over them. For reasons stated herein, the court finds no basis for the dismissal, and all filings, to the extent that they can be taken to request relief from the court, be denied. Number A, claim that the court does not have jurisdiction over the defendant's charges. Here, the judge explains where he gets the authority to arrest Heather, and he fully explains it in detail. Quote, Article 3, Section 1 of the United States Constitution provides in pertinent part that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish, cites the Constitution. Quote, Section 2 explains that the judicial power shall extend to all cases in law and equity arising under this Constitution and the laws of the United States. By statute, Congress has declared that the district courts of the United States shall have original jurisdiction exclusive of the courts of the state of all offenses against the laws of the United States. Moreover, any offense against the United States begun in one district and completed in another, or committed in more than one district, may be inquired of and prosecuted in any district in which offense was begun, continued, or completed. The offenders are charged with wire fraud, bank fraud, and money laundering allegedly occurring in the Eastern District of Tennessee. Because the defendants are charged with violation of federal law in this district, the United States District Court for the Eastern District of Tennessee unquestionably has jurisdiction over its case. See United States v. Pryor, holding the fact that the defendant was charged over federal statute to provide court with federal question subject matter jurisdiction. Alright, so just to go over, once again, the judge's explanation of where the court gets its jurisdiction. Article 3, Section 1 of the Constitution gives Congress the power to do blah, blah, blah. And then Congress did blah, 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 and that is what gives the court jurisdiction over wire fraud, bank fraud, and money laundering charges that happen in the Eastern District of Tennessee. Because Congress created a court that would deal with federal crimes committed in the Eastern District of Tennessee. Moving on. Bean was taken into custody on an arrest warrant, brought into custody on a writ of habeas corpus ad prosequendum. Heather was brought before the court on a federal arrest warrant. Our appellate court has held that federal courts have personal jurisdiction over criminal defendants before them, whether or not they are forcibly taken into court. Accordingly, this court has in personam jurisdiction over the defendants. B. The defendant's claims have no legal support and defy common sense. The defendant's claims fall into three main categories. Number one, the United States government no longer exists because it was a corporation which was foreclosed by Heather and 2C Giraffe and others acting on behalf of the public trust. Number two, various UCC finding statements, amendments created and filed by 2C and others constitute a judgment against the United States government. And three, as a result of this foreclosure, the only authority over the defendant is that to which they consent. The principal idea, there's a typo there, it should be principal. The principal idea, or maybe it's principal anyway, undergirding the defendant's arguments is that an unrebutted declaration has the force of law. The court briefly examines each of the defendant's claims and finds that they have no basis in law or fact. Number one, defendants claim that the United States is a corporation based upon U.S. 28 U.S.C. section blah blah. This statute only defines certain terms as used in the Federal Debt Collection Procedures Act. Subsection 15 defines the United States only when used in the Federal Collection Procedures Acts. Thus, even within the Act, the United States is not transformed into a corporation nor limited to being a corporation, as the defendant suggests, but includes any agency or department of the United States government. So others claim that the United States government is a corporation is wrong. In other words, the Act does not purport to define the term United States for any purpose other than the collection of federal debt. The statute raised by the defendants does not in any way apply to this case and has no effect on this court's jurisdiction in this criminal case. I'm just going to keep calling it. In note 14, the Corporation for Federal Broadcasting, the National Railroad Passenger Corporation, and the Tennessee Valley Authority are just a few examples of federal corporations. So it gives examples of where the definition would apply. In case you didn't know what a federal corporation is. Quote, Heather and Bean's assertion or declaration that the United States is a corporation is also frivolous. The defendants has also contended that the multiple UCC financing statements that they have included in their filings constitute a perfected judgment against the United States that prevents the defendant's prosecution for federal crimes. To the contrary, the numerous UCC filings have no relevance whatsoever in this criminal case. First, as Heather acknowledged, the UCC is not a law and has no legal effect or force in and of itself, when it's instead a proposed model code developed to promote uniformity in commercial transactions. In the various states, each state adopts its own commercial code. Going back to annotation 15. The defendants apparently do not espouse the definition of judgment from the same FDCPA, from which they pluck the definition of the United States. In that act, judgment means a judgment ordered or decree entered in a court. Quote, this is but one example of the numerous internal inconsistencies in the defendant's argument. This example illustrates how the defendants pick and choose various snippets of law, the very law they claim no longer exists, and then misapply those fragments to try to shore up their fantastical legal theory. Just to restate that point, the act that Heather is quoting says that judgments can only come from courts. The fact that, which contradicts her claim that she can get a judgment without a court. Moving on. Blah, blah, blah. Each state belongs to defendants. Where were we? The UCC filings that are part of the press to be dismissed were filed and recorded in Washington, D.C. I posted those on all their videos. The defendants argue that their filings include language that would make these filings applicable in all jurisdictions. However, as discussed in the motion hearing, the defendants' bare assertion of a fact or premise does not make it true. The defendants have provided no authority for their contention that they can file a UCC financing statement amendment in Washington, D.C. and somehow divest every federal court nationwide of the ability to prosecute them for federal crimes. Second, the defendant filings are sham UCC financing statement amendments, wherein Heather purports to amend a UCC financing statement, but references no current record to be amended or supplemented. The UCC financing statement amendments do not allege a bona fide financial transaction, but instead contain a declaration of facts made up by Heather and others. The fact that the defendants were able to state their worldview on a UCC financing statement amendment form and have them filed by the Washington, D.C. Recorder of Deeds does not shield the defendants from indictment, prosecution, or liability in this federal case. See Harris. In Harris, the defendant filed a UCC financing statement and a security agreement in support of his claim that the court lacked jurisdiction over him. The court rejected the defendant's ploy. So Heather isn't even the first person to try this UCC stuff, and the judge quotes from another case in which another guy tried UCC stuff to stay out of jail. Quote, just because Harris unilaterally chooses to call something a commercial transaction or a UCC financing statement and security agreement does not necessarily make it so. Just because Harris was able to file and record the UCC financing statement and security agreement with the Michigan Secretary of State does not make the documents legally valid and enforceable under the Michigan UCC. The office of the Secretary of State merely accepted for filing this document is submitted to it. The mere act of filing or recording the sham UCC financing statement and securities agreement does not automatically make the documents legally valid and enforceable under the Michigan UCC. So this is directly contradicting Heather's main claim that the filing of the document automatically makes it valid and enforceable. It does not automatically become valid and enforceable. But the bottom line is that defendant James Devin Harris, James Devin Harris L., this was a Moorish guy, cannot avoid indictment, prosecution, and liability in this criminal case based on his sham UCC financing statement and security agreement. Likewise, Heather and Bean gain no traction with their jurisdiction argument by making declarations on UCC financing forms. Finally, the defendant's UCC filings do not constitute a lawful judgment. At the motion hearing, Heather argued that her declaration of facts, which was stated on UCC forms, constituted a perfect judgment. She contends that this judgment is binding on the court because she alleged these facts and no one has rebutted them. She claims as one of her 10 maxims of law that a duly sworn, verified, and validated declaration made with due signature and seal, duly unrebutted, specifically and particularly stands as law. And he cites the document in which he said that. At the motion hearing, Heather could provide no legal authority for this maxim and could only assert that it is universally known. As Heather, who was formerly a licensed attorney, well knows, a judgment is, quote, the official and authentic decision of a court of justice upon the respective rights and claims of the parties to an action or suit therein litigated and submitted to its determination. Black's Law Dictionary, 4th edition. So he gives the definition of judgment to explain why Heather's document is not a judgment. It needs to come from court. Providing that in the judgment of conviction, the court must set forth the plea, blah, blah. A UCC filing, even a legitimate one, is not a judgment. Clear as day from explanation from the judge. The defendants argue, as a result of their alleged foreclosure and judgment, both of which have been discounted above, the only authority over them is that to which they consent. While the defendants deny that they are sovereign citizens, they assert the typical arguments of those espousing sovereign citizen views, which is that the defendant is sovereign and above the law. Here, the defendants argue that they are not subject to the jurisdiction of the United States courts because they have not consented to the court's authority over them, and that indictments may only be issued by the individual who is charged therein. Although the instant defendants wrap their arguments in the novel package of the One People's Public Trust, the defendants' assertions are in essence time-worn sovereign citizen arguments have been uniformly rejected by federal courts for decades. And we have this is subscript 16. At the motion hearing, this is a good one. Heather argued that an indictment can only be issued by consent. She claimed this applies to her and all other people. Her incredible and absurd argument that no criminal charges can be brought against her or anyone without that individual's is that no charges can be brought against anyone without that individual's consent. Under her reasoning, anyone can commit any criminal act, burglary, robbery, assault, drug trafficking, or even murder, but cannot be prosecuted unless they consent to being prosecuted. Even the least dedicated of us, would be myself, would scoff at this notion. However, those intent upon preying on others would relish under such a proposition. Such a system would be untenable, and no nation, country, state, or community could exist under such a preposterous proposition. That's just common sense. Society could not function if you needed murderers' permission to put them in jail. Obviously, they're not going to agree to be put in jail. You have to do it without their permission. Moving on, we have case law that states clearly, quote, the laws of the United States apply to all persons within its borders, quote, Bay v. United States. Moving on, we have case law that states clearly, quote, the laws of the United States apply to all persons within its borders. This is true even if the individual does not consent. The jurisdiction of this court is provided by statute, 18 U.S.C., and the defendants were brought before the court through valid legal process. No UCC filing, special oath, phrasing, or legally served to divest the court of its jurisdiction. The court finds that the defendant's contention that this court must dismiss the case due to a lack of jurisdiction should be denied. And here we got to the conclusion. After carefully considering the parties' filings and arguments and the relevant legal authorities, the court finds no basis to dismiss the indictment. For the reasons set forth herein, the judge recommends that the defendant's filings be dismissed, be denied. He also recommends that the supplemental filings also be denied. So the likely end result of this is that all this stuff is going to be denied, obviously. The phrase common law gets thrown around a lot on my channel and on sovereign citizen websites and forums. But this is how common law works. The judge explains what the law is and clearly explains it to the audience, to the public at large, so that we can understand. All right, number one, he explains where the court gets its jurisdiction from. He explains why Heather's UCC filings are nonsense. He explains why she doesn't have a judgment. He explains why the United States is not a corporation. What else? He explains what else? In detail, the UCC filings and why they're not, why they don't have any validity. Documents like this report and recommendation are common law. They're case law. They're meant for people over at IUV and the public at large to read so that they can understand what the law is, so we can avoid getting arrested like Heather and Randall did. this is real law. This is not the nonsense that Heather is saying. What Heather is saying has no validity. I don't know how much clearer to say other than, yeah, better than the judge did. I can't do that. You know, it's a real shame that this has escalated to the point where Randall is now facing something like 200 years in jail. Heather is facing less. This is a problem with internet nonsense. You know, it starts, you know, innocent, you know, with a web radio show, you know, some crazy ideas about secret accounts. Next, you're in jail. Let me rephrase that. The most radical part of Heather's doctrine is that she denies that objective reality exists. She believes that her thoughts and her feelings can alter reality. That's not true. How you feel about a situation is not going to change it. It will change how you feel about the situation, but it won't change that you will end up in jail. It will not. You know, you cannot push hurricanes out of the way. You know, you can't magically think a roof back up upon your head. You know, this is the problem with that kind of crazy thinking. You'll end up in jail because you're not thinking straight.